What I witnessed in this hearing shocked me. Chairman Jim Jordan grilled witnesses about the FTC's actions on free speech, privacy, and AI innovation. His questions exposed disturbing truths about government overreach and big tech's role in shaping AI. Let me break down what happened. Chairman Jordan pressed Mr. Chilson, former FTC chief technologist. Is it appropriate for the FTC to demand a company reveal which journalists it talks to? Chilson's answer, no. Yet the FTC sent Twitter a letter naming independent journalists, demanding all communication with them. That's not oversight, that's intimidation.
Mr. Chilson, you worked at the FTC, is that right?
That's right.
Chief technologist at the FTC, I think was your title?
Acting chief technologist, yes.
Yeah, and you focused on, I'm looking from the bio here, the economics of privacy, blockchain-related issues. Is that accurate?
That's correct.
Work for the commissioner.
Yes.
Yeah, and you're an attorney as well?
I am, yes.
You understand the Bill of Rights, the Constitution, all the things they teach us in law school and all that, all those important. Is it appropriate for the FTC to ask an American company, the journalists, that they have communicated with?
I don't think so, sir.
I don't think so either, but that's exactly what happened at the FTC Mr. Bedoya works at just a couple years ago. They sent a letter to Twitter after Mr. Musk had purchased the business and said it's recently reported that Twitter has been providing certain third-party journalists information. And they named the journalists. Barry Weiss, Matt Taibbi, Michael Schellenberger, Abigail Schreier. They name the journalists, and they say this: identify all journalists and other members of the media to whom you've granted any type of access to the companies of communication. Is that appropriate?
I don't see what it would have to do with most of the types of actions that the FTC would bring.
Seems to me it's totally getting at, violating the First Amendment, freedom of the press. You got a right as a company, people in a company, to talk to journalists. And yet the FTC wants to know any and every journalist you've communicated, named 4 specifically, and wants to know any others you've talked to. What do you think, Mr. Chilson? Pretty bad stuff that was going on there?
Yeah.
Then things got even stranger. Jordan questioned why the FTC wanted to know why Twitter fired Jim Baker, a former FBI lawyer. Baker played a central role in the FBI's surveillance abuses during the Trump campaign.
Let me ask you this then, too. They also they wanted to know every reason why Twitter terminated former Twitter employee Jim Baker. Do you know anything about that, Mr. Chilson? Why they'd be asking about that guy?
I don't know much about that, and I don't know why they would.
I got my hunches. Jim Baker was the general counsel at the FBI when the FBI was doing all the crazy things, going to the FISA court, getting warrants, spying on presidential campaigns. He then goes to work at Twitter. Mr. Musk buys Twitter and says, I'm going to get rid of this guy. And now the FTC wants to know why? I find that strange, too. Every journalist you've talked to and why you got rid of Jim Baker.
Another powerful exchange came when Jordan questioned Ernst Young, the firm chosen as an independent assessor in Twitter's case. Under oath, an executive admitted the FTC pressured them, hinting that unless they found negative results against Twitter, future contracts could be at risk. That's not oversight, that's coercion. If true, the FTC was using its power to manipulate outcomes.
Let me ask you another one. Ernst Young was named the assessor in the consent decree focus between the FTC and Twitter. The specific assessor was a guy, David Roque. He testified under oath and said, quote, that if Ernst Young did not include negative findings against Twitter, the FTC raised the specter that it would create other challenges for Ernst Young over time. Does that seem to be the kind of communication that should be going from the FTC to the assessor at Ernst Young, Mr. Chilson?
It seems like a form of soft coercion.
Yeah, is that accurate, Mr. Bedoya? Did you guys do that, Mr. Roque? Again, this is under oath in the case. Is that what happened at the FTC? Why would you tell Ernst Young, you better find out the right thing, you better find something negative against Twitter, you may not get business with us over time?
Thank you, Mr. Chairman, for the question. I'm not familiar with that particular communication, and so given that I am under oath, I don't want to give a wrong answer here.
So are you disputing whether it happened or not? It's a court filing.
No, sir, I'm not disputing that. I'm just saying I'm not familiar with that particular communication, and like you said, I'm under oath.
I'm asking you if it's appropriate or not. It happened. Here's what he said. If Ernst Young did not include negative findings against Twitter, the FTC raised the specter that it would create other challenges for Ernst Young over time. You hire Ernst Young to be assessors in these kind of consent decree arrangements all the time. can see the obvious threat there. I'm just asking if that's appropriate.
Mr. Chairman, who is saying that statement? Who's writing
The
it?
documents that David Rowe communicated in the court that we have that
Mr.
point this out.
Forgive me, Mr. Rell is an Ernst Young executive?
Yeah, he's the assessor you guys hired.
And he was, I'm sorry, I take this very seriously, and so what I would ask is if you submit it for the record, I'll take a good look at it and give you a full and complete answer.
The hearing turned to artificial intelligence, focusing on three big warnings: vertical integration, big companies controlling both cloud infrastructure and AI models, privacy concerns, especially facial recognition, and surveillance risks.
Bedoya raised three concerns earlier, and I just got a few seconds, but I wonder if, and any of you three can comment on this. Three warnings that he pointed out: vertical integration, AI keeping private data private, and then the surveillance concern. Do you have a different perspective on those three concerns, or tell me what your thoughts on the three warnings he laid out in his testimony?
Thank you for the question. I can start with the first one about AI partnerships and vertical integration and anti-competitive conduct. I think that the concerns about foreclosure, which are the typical anti-competitive harm that you think about when you go with vertical integration, are certainly very premature at this stage. We see robust competition at the foundation model level and the cloud level, which suggests that a vertical integration between, let's say, a cloud company and a foundation model is unlikely to result in any sort of exclusionary conduct. With respect to the partnerships and sort of a horizontal, so to speak, reduction of competition between, let's say, a big tech firm that may have a partnership, and the idea being that because they're investing in these companies, they're less likely to compete. Again, I think it's unlikely that that's going to result in a substantial lessening of competition, again, because of the robust competition that exists at the foundation model level, but also because of the pro-competitive benefits that these partnerships can have, specifically providing AI foundation model startups with the sort of patient capital they need to grow sustainably and actually innovate faster.
Experts warned that AI can infer sensitive information, raising big questions about privacy and freedom. This hearing revealed more than political sparring. It showed how agencies like the FTC can threaten press freedom, meddle in business decisions, and shape how AI develops in America. Chairman Jordan made it clear, our rights and innovation are at stake. Subscribe to stay ahead of the truth.